Good afternoon. Just a quick reminder, the oral arguments, unless we put an order down saying otherwise as to a case, oral arguments are streamed out and will be on to the Administrative Office of the Court's website, for YouTube website. So just keep in mind. Call the first case, please.
Re Sawyer B.
We'll hear from the appellate when you're ready.
Okay, Your Honor, I'd like to reserve 3 minutes.
Would you pull the microphone down some, please? Thank you.
Is that better? I'd like to reserve 3 minutes.
That'll be fine, 3 minutes.
If it may please the court, my name is Glenna Overton Clark. I represent the biological mother in this case. The petitioners allege that the child was in an unsafe environment. What the trial court did was that it just adopted the juvenile court's ruling that they found that another one of the biological mother's children had been abused. She testified in juvenile court that she was unaware of this abuse because she was not at home when the alleged abuse occurred. We agreed that she was in an abusive and controlling relationship and made it difficult for the mother to immediately seek relief by removing herself and her family from the home because of the abusive and controlling relationship. There was no proof presented that the child that's question of this case was ever in danger. However, juvenile court, and I agree with juvenile court, in the best interest, removed all the children to protect the children. DCS gave the mother 3 steps that she needed to take to regain custody of the children. One was, of course, to find alternative housing, was to move out. The mother testified in this case that she could not find alternative housing, that subsidized housing, there was a waiting list, she couldn't afford anything else, and her mother had no room at the inn. She finally was able to move out when her mother, the grandmother, had a room open so she could move her children out. The second was that the mother was to become gainfully employed. While she was in this abusive relationship, the boyfriend controlled the money and controlled her and would not allow her to work. Once she moved out, she became gainfully employed and she paid child support. And the third was for the mother to have therapy, which she did obtain. So she'd done everything in her power to meet the requirements of DCS, but then the petition for termination.
When did she, was it Mr. Berger, was that the individual?
Yes.
When did she move out?
It was Thanksgiving, but I cannot remember the year, Your Honor.
Was it after the termination petition was filed?
I believe so.
Did she give any reason why? I mean, I know what you said about he controlled her and controlled the money and no place to go, but other than that, did she give a reason why, even though she'd been told this, that she still didn't move until the petition to terminate was filed?
She had no place to go.
But after the petition to terminate was filed, she found a place.
It was after the termination was filed, and then her mother had some relatives living there that they moved out. Then her mother had room for her to come, and it was under a guise that she was going to spend Thanksgiving with her mother is how she escaped. She didn't take any of her belongings with her when she left the home.
But didn't she say when she was questioned about that she really couldn't give an answer as to why she hadn't moved a year before?
You're correct, Your Honor. She did, because when you look at the whole situation, she was trying to find a place that was safe, but she couldn't answer Chancellor Weaver and say specifically why, but he was controlling. He was stalking her and everything. So it was a very controlling situation. The petitioners didn't present any expert testimony as to whether or not it was in the best interest of the child to not be with the mother, or whether or not it was in the best interest of the child to be with the petitioners. The only testimony that was presented on the best interest was the self-serving testimony of the petitioners. The mother did attempt to have supervised visitation while the child was with the petitioners, but the petitioner refused to pay the intake fee, and my client couldn't afford both sides, and she couldn't see the child. It had to be supervised at that point because DCS had not cleared her. Plus, during all this time, unfortunately, like as I said this morning, the pandemic hit, and she lost her job because of the pandemic, so she couldn't pay for the intake fee. And then once she could, she got a job again. Also, what was outside of the mother's control was, what was outside the mother's control was the fact that of the pandemic, she couldn't find a job. And the other thing was the court system. This case drug on. I'm not saying there was anything wrong with the court system, but if we all recall, during the COVID-19, we pretty much shut down everything. During all this time, she couldn't have quality time with her child. So here again, I don't know. Like I said, there was no testimony as to what was in the best interest of the child. There was a question raised at trial as to why she didn't appeal the juvenile court order, and she testified she didn't know she could. Her attorney, her court-appointed attorney, didn't tell her that she could appeal it to the circuit court and didn't even give her the order, just said the children will be removed. It took courage for...
That's grounds in and of itself perpetration of severe child abuse, isn't it? Wouldn't that be grounds in itself?
The mother didn't realize that there was any severe child abuse because she was not in the home.
With the conviction, though.
The conviction of it, yes, but she still was she didn't know she could appeal it whether or not there was severe child abuse. So she didn't take that final step because she just didn't know. She finally had the courage to leave the abusive relationship. She jumped through all the hoops with DCS. She tried to see her child, but the petitioners were not willing to let her see the child. The mother is of the opinion that it's not clear and convincing evidence that she abandoned the child because she was trying. She did pay child support, and there has been no expert testimony that it really is in the best interest for the child to not be with the mother. And I think the big step here is the fact is that as soon as she could, in her mind, she removed herself from the abusive relationship and made steps to try to regain her children. So we ask that the court would reverse the trial court.
You have your time for rebuttal. We'll hear from the appellees.
Thank you, Your Honor, for it please the court. My name is Megan Bodie. I'm here for John and Kelly Wilson, the appellee. This case was filed in July of 2021, and at that time, we had pled several grounds for termination. Prior to trial, though, we withdrew all of the grounds except for severe abuse, and that was based off of the order out of the Knox County Juvenile Court from August of 19, where the mother was found to have committed severe abuse against a half-sibling of this child Sawyer that we're here for today. That order went down September of 19. The mother was represented by counsel during that trial. She had an opportunity to appeal that decision. She did not do so, so it became a final order. At trial, our proof, as this court knows, we have to prove one ground for termination and that the termination is in the child's best interest. So at trial, we presented a certified copy of the juvenile court order showing that the mother had committed severe abuse against a half-sibling. So that was the only proof that we had on that issue because that is the only proof that's required of us under the statute. There's case law from this court that has made it clear that a prior order from a court finding a parent or guardian has committed severe child abuse suffices as the ground for termination, and that it is not required that a petitioner relitigate the severe abuse in the termination court. The court in Re Serenity held that the doctrine of res judicata applies, and so long as the mother had an opportunity to litigate that severe abuse issue and she was heard, once it's final, it's final. So we believe that we, by clear and convincing evidence, proved the ground for termination at the trial court level. Based on the ground being met, we moved to best interest, and I would strongly disagree with counsel that there was not sufficient evidence at trial to address best interest. First of all, I don't believe that expert testimony is required in order to prove best interest. This court is well aware, again, that there are 20 factors that the court must consider when looking at best interest. Each factor has to be proven by a preponderance of the evidence, but collectively they have to be proven by clear and convincing evidence, and we believe that we have done that. It's also important to note that the court can rely on one factor more heavily than the other if necessary in order to decide a case. And so instead of going through every factor today, because a lot of the facts in this case meet several factors, I wanted to highlight the ones that I believe are most important for our case with Sawyer. The first factor is the effect of termination of parental rights on the child's critical need for stability and continuity of placement throughout the child's minority. This child was 10 weeks old when she was placed with my client, Kelly Wilson, and when we had the trial in this matter, she was 5.5 years old. She sees my client and her husband as her mom and dad. She's the only parents they've ever known. This is the only house that she's ever lived in. And so to remove her potentially from that down the road would be detrimental to her. So in order for Sawyer to continue in a safe and stable environment, we believe the first factor weighs heavily in favor of termination. The next factor I believe is important when determining this case is factor number 10. And again, the factors that I'm not going over, we still believe weigh in favor of termination. I'm just highlighting the ones for interest of time that I feel
The trial court basically went through most every factor in his
Yes,
judgment,
Your Honor. He went through every one of them and gave his reasonings, and we agree with what he said. Really, the main facts of this case that go to many of these factors are that Miss Black remained in a relationship with Mr. Barger until, I believe, 5 months after we filed our petition in this case. Not only did she maintain that relationship, she actually had children with him that were born in May of 22. So for her to say that she was trying to get out of this relationship and she just couldn't figure out how to get out of it seems disingenuous given that she had children with him several years later. She also had a job, numerous jobs during the time that Sawyer was with my client. She never paid any child support or offered. There was no order, and my clients didn't ask, but I think most parents would understand that children require some funds to help raise them, and she offered no financial support to the Wilsons. She also did not visit, and we withdrew this ground, but it is important for purposes of best interest. She did not visit for 4 months prior to the filing of our petition, and she can say that that's based off of the petitioners not allowing her contact. But the testimony at trial was that my client, Ms. Wilson, who had supervised some of her visits in the past, had not changed her phone number in 15 years, whereas the mother had gotten a new phone and lost all of her contacts. So there wasn't any proof that she could present where she had actually reached out to the petitioners and asked for visitation, and they turned her down. She did say that she did engage in therapy, but her testimony also was that as soon as DCS closed their case, she quit going to therapy, so she hadn't really complied with what the juvenile court had asked of her. And so for all of those reasons, we believe that the trial court was correct in their ruling in this matter, that we had met our ground for termination by clear and convincing evidence. We had proved best interest by clear and convincing evidence, and would rely on Chancellor Weaver's very thorough analysis of the best interest factors, and ask this court to affirm his ruling. Thank you.
Thank you. We'll hear from the appellant in rebuttal.
Thank you, Your Honor. Ms. Bodie's position is that, Ms. Bodie's position is that once there's been a severe abuse, it's been found, even though the mother removes herself from the situation, that she can never get her children back again. It wasn't her that, yes, she was charged with abuse because they said she didn't do anything, but she testified she didn't know it was going on.
She was charged. She was convicted.
She was convicted, but she also took the steps to rehabilitate herself, for the lack of another word, to remove herself from that situation, to change it. And so Ms. Bodie's position is, and if this court is of agreement, that she should be penalized for this instance, which is not minor. I'm not saying that this is not a minor issue, but the fact is that she was trying to do something, and so she was being penalized because there was that conviction, but she was trying to correct herself. She testified that she was trying to do everything she could to regain her child, Sawyer B. She allowed, she agreed that this was her child that she wanted to raise, and she did lose the cell phone number of Kelly Wilson, but even while this case was pending, she attempted to try to see the child, and Kelly Wilson would not allow it. Here again, the fact that the Sawyer B was 5.5 years old is the court system's delay, and at that point, I was not in the case, but it was the delay of that. I think it is unjust for the mother to be penalized when her biological child is removed and she tries to correct everything. I think it's unfair that she shouldn't be given a chance. And in this case, she just was asked to have a chance to prove that it would be in the best interest for Sawyer to see her mother, and to be with her mother. Thank you, Your Honors.
Thanks to counsel from both sides. We appreciate your arguments and your briefs in this matter.